Welcome to the 2019 Hearing Officer and Tribunal Member Training Update. This update is sponsored by the Georgia Association of Educational Leaders and the Georgia Department of Education Policy Division. This update is for individuals who have completed the 5-hour basic training class required by state law and by state board rule. The 2019 General Assembly did not pass any laws which impact discipline for the 2019-2020 school year. That's good news. But there have been a number of problem issues throughout the state during the 2018-2019 school year, and we want to make you aware of those and how to deal with them. The first is appeals. We've had an unusual number of appeals of tribunal hearings made to local boards of education. A review of the process is important. Board appeals are based on the record only. No new testimony, no new evidence may be introduced into the appeal hearing. Parents or attorneys have to file a notice of appeal with the superintendent within 20 days of the completion of the hearing. The Board of Education must then render a decision on the appeal within 10 days of receiving the appeal. The board may support the ruling of the tribunal or hearing officer. It may overturn the ruling of the tribunal or hearing officer, or it may modify the ruling of the tribunal or hearing officer in any way that it sees fit. There have been a number of appeals to the State Board of Education of hearings which are held at the local level and have been appealed to local boards of education. If the parents or attorneys choose to appeal the decision of the local board, then that process is outlined in State Law 20-2-1160. After the appeal hearing is held at the local board level, the local board of education must notify in writing all parties within 15 days of its decision. That does not include holidays or weekends. The local board of education is also required at the time to notify the parents of their rights to appeal to the State Board of Education. After a hearing under the procedures set forth above, either party may appeal to the State Board of Education by filing a written request for appeal with the local school superintendent, not with the state school superintendent, but with the local school superintendent. This request must state the question in dispute, the decision of the local board, and a concise statement of the reasons why the decision is being appealed. This appeal should be addressed to and filed with the local school superintendent within 30 days of the decision of the local board of education. The request for the appeal should not be sent directly to the State Board of Education. A transcript of the proceedings must be filed with the appeal to the State Board, and that is specified in State Board Rule 160-3-.04. And that rule also sets forth who pays for the cost of the transcript. Upon receipt of the appeal, the local school superintendent will transmit to the state school superintendent a copy of the appeal request together with the transcript of evidence and proceedings, the written decision of the local board, and any information in the file relating to the appeal. The local school superintendent has 10 days after receiving the request for an appeal to transmit the documents to the state school superintendent. If the appeal is in proper form, the state school superintendent, through the Legal Services Division, will inform the parties that the appeal has been docketed and what types of information will be required and what timelines to follow. Hearings for withdrawn students. There has been some conflicting information around the state about whether or not to hold hearings for students that have withdrawn after they have been notified that they are suspended pending a hearing, tribunal hearing in the local district. If a student is informed that they are charged with a tribunal offense and that a hearing will be held, the hearing must be held regardless of whether the student withdraws. If the student enrolls in another school system, that school system should be notified of the student's disciplinary sanctions. Failure to conduct the hearing may result in the student returning to the school system after 10 days with no disciplinary consequence. So you must hold the hearing. If you tell a student you're going to hold a hearing for them, hold the hearing whether the student is present or not. It is not necessary for the student nor the parents to be present in order for a hearing to be conducted. Off-campus felony arrest. There are a number of cases in Georgia each year resulting from students being charged with felonies for off-campus events. The procedures for dealing with a student who has been charged with an off-campus felony are detailed in State Law 20-2-768. Each local board of education is authorized to refuse to readmit or enroll any student who has been suspended or expelled for being convicted of, being adjudicated to have committed, being indicted for, or having information filed for the commission of any felony or any delinquent act under the Code Sections 15-11-602 and 15-11-707, which would be a felony if committed by an adult. If refused readmission or enrollment, the student or the student's parents or a legal guardian has the right to request a hearing pursuant to the procedures provided for in Code Section 20-2-754. Students charged with a felony off campus may be placed in alternative school until they are adjudicated. The placement is made by having the superintendent write a letter to the parents informing them that the student has been placed in the alternative school until they are adjudicated. If the parents object, a hearing must be held to place the student in the alternative school. If the student is found not guilty or is found guilty of a non-felony offense, another hearing is not required. The student is simply returned to school. Once the adjudication occurs, a hearing must be held or a waiver signed if the student is found guilty of the offense, and if placement is to continue or if a more severe punishment such as expulsion is recommended. Included in jurisdiction for off-campus or off-property behavior is the important point that proof exists that the behavior jeopardizes the safety of students and their staff. If a student is adjudicated and found guilty of a felony, the student may be expelled with the opportunity to attend an alternative school, or any lesser penalty following a hearing or waiver. An interesting case occurred in the state of Georgia this year. Students A and B were dating, and the student A is charged with statutory rape, a felony to which he pleads guilty. The families of the students involved did not want any further action taken against student A. It was recommended that they proceed with a hearing and make the appropriate recommendations to the hearing officer or tribunal. That recommendation was made, and the student was permitted to return to school under much less serious sanctions than expulsion or placement in alternative school. A troublesome issue in discipline is dealing with students that have been charged with making a terroristic threat toward the school or toward students. These threats are commonly made via social media. The question comes as whether or not the student may be permanently expelled or expels for a specific period of time. Official Code of Georgia 20-2-690.1 clearly gives the school system the authority to expel a student, particularly when there is a threat to the safety and security of the school. Such expulsion may be made only after a due process hearing. And during that due process hearing, it is important to establish that the student's return to the school will represent a threat to the safety and security of the student body. The parents may sign a waiver in such circumstances. In a Hall County case, which is Major versus Georgia, The Georgia Supreme Court has upheld a school system's authority to charge or expel a student making a terroristic threat on social media. How do we deal with students that have been sent to RYDC? Students that are sent to RYDC or incarcerated do not forfeit their right to a due process hearing. The hearing must be held within 10 days of the notification as specified in 20-2-754. If the notification is provided before or while the student is incarcerated, the clock begins and the hearing must proceed within the 10 days even if the student is not present. Please be reminded that students and or parents are not required to be present in order for a hearing to take place. If the student is not suspended pending a hearing before the incarceration, the student may be suspended pending a hearing upon his return from the incarceration. School leaders are advised to take the route of a suspension and hearing upon return from incarceration so that the student may be present for the hearing. In both cases, students may postpone or reschedule the hearing with the school system's permission, but the student should remain out of school. Please be reminded that any hearing may be postponed by mutual consent of the school system and the parents. The law is very clear in that it gives school systems the right to expel students for cause. Services do not have to be provided to an expelled student unless the student is special needs. A school system may provide services for other students at their discretion. They are not required to provide the services. It's at the discretion of the local school system that they provide services to an expelled student, regardless of age. Please note that 20-2-690.1 does not say anything about age or grade. There is an exception to this for students in grades K through 3, which will be discussed later. Students that are expelled from a school system may not enroll in another school system in Georgia until the terms of the expulsion are completed. A limited number of state charter schools are authorized to accept expelled students, but that is a function of their specific charter. Again, these are state charter schools, not charter systems. If there are state charter schools or local startup charter schools in your area, it may be problematic if they expel students. Expelling students from charter schools, not charter school systems, but from state charter schools and startup charters, may be problematic if the charter school expects the student to return to their home school. Expelled students may not return to regular home school if they are expelled from a charter school. If the charter school does not have an alternative school, the student is out of school unless the hearing in the charter school stipulates that the student may attend an alternative school if they are accepted in a school that has an alternative school. Once again, students that are expelled from charter schools, we're not talking about charter system schools, but from independent charter schools. Students that are expelled from those charter schools may not be accepted back at their home school if they have been expelled by the charter school. Dealing with Section 504 students can often be problematic. Here are some issues that should be considered in dealing with 504 students. 504 students should have an individualized plan based on a needs assessment. Simply assigning a student as a 504 student without a needs assessment is not well advised. The support committee should be similar to an IEP committee. If a student is charged with an offense for which a tribunal hearing could be held, a manifestation prior to the hearings to determine the influence of the 504 condition should be held. If it is a manifestation of a student's condition, that information should be shared with the tribunal and or hearing officer prior to a hearing. All 504 students charged with a tribunal offense go to a hearing regardless of whether or not it is a manifestation of his 504 condition. But if it is a manifestation of the 504 condition, that should be reported to the hearing officer and tribunal, as well as the deliberation that took place in the support committee's deliberation. 504 students are not subject to the 10-day rule as our special needs student, nor are they subject to the 45-day rule. Every school and school system has to deal with students that are different. These students are not 504 students, nor are they special needs students. But school systems are experiencing more and more students that have emotional issues and have experienced difficulty relating to other students and our teachers. These students may receive student support team evaluation and support, as well as expanded counseling services. If the comprehensive evaluation of the student does not produce a recommendation for identification as a Section 504 student or as a special needs student, the student is not protected by federal regulations for students with disabilities. Students under this condition are therefore subject to disciplinary procedures just as any other student. The tribunal hearing officer certainly may take such factors into consideration in determining the appropriate consequences if the student is found guilty. But once again, if the student has not been labeled 504 or special needs or placed in those categories, then the student has the same disciplinary consequences as any other student. Smaller school systems often have their high schools placed in the county, not in the city limits, and there becomes a problem with who has jurisdiction with regard to those school campuses. City police jurisdiction or activity on county school campuses that are not in the city limits of the city. And this is particularly important with regard to drug dog screening, is consistent with state law. Any law enforcement officer that comes on a school campus, including SROs, are subject to probable cause regulations. School administrators are under the reasonable suspicion regulations, but law enforcement officers are not. Please use caution in permitting law enforcement officers operating out of your jurisdiction from coming on campus and conducting investigations or interrogations. When students are called as witnesses in tribunal hearings, there are some important elements to be considered. First, subpoenas may be required in order to get a student to attend a hearing. If a student refuses to attend the hearing, they may be required to attend via a subpoena. The subpoena may be signed by school officials, or it may be signed by the parents of the students if a student is to testify for the defense. A parent does not have to give permission for a student to be summoned to a hearing, nor for them to testify, but they must be informed. The parent may accompany any student witness to a hearing. They may sit with the student during the hearing. They may counsel the witness, but they may not testify unless given permission by the hearing officer. Students are subject to the 3-day rule, in that if it's necessary, the student may be given 3 days in order to prepare for testimony in a tribunal hearing. In those cases, you have to postpone the tribunal hearing to accommodate the notification of the witness. Suspending and expelling K through 3 students. The 2018 General Assembly passed House Bill 740 in 2018, and the law has been signed by the governor and prescribes certain disciplinary processes for students in grades K through 3. Under the law, K through 3 students may not be suspended out of school or expelled for more than 5 days total per school year without the response to intervention or MTSS process being in place. The issue becomes what to do with students in grades K through 3 if they are expelled. State Board of Education policy defines alternative school for grades 6 through 12. Legal counsel has ruled that since it is not prohibited by the law, K through 5 students may be served in the alternative school for 6 through 12 students if there is a local board policy that permits such placement. Cases involving possession of weapons on campus have not diminished. The possession of a weapon or an object used for threatening or intimidation subjects the student to a tribunal hearing. Students may not be expelled unless it is shown that the weapon or object was used in a threatening or intimidating manner. The alleviation of expulsion for such students does not alleviate law enforcement sanctions. Law enforcement sanctions still apply. The Code of Georgia is applicable to any student in possession of a weapon on campus, whether or not it was used in a threatening or aggressive manner. There have been some issues associated with how we treat students who return from expulsion. A student returning from expulsion may not automatically be assigned to alternative school unless there is a local Board of Education policy stating such, or unless the return to alternative school is a part of the tribunal or hearing officer decision. Once the tribunal has begun its deliberation over innocence or guilt or on consequences, witnesses or school administrators may not be summoned to the closed tribunal deliberation for additional testimony or advice. If additional testimony or clarification is needed by the tribunal, the open hearing should be resumed and the request for information be made in front of parents and or students. Under due process, the student or family has the right to cross-examine any additional information provided to the tribunal or hearing officer even during the deliberation process. That concludes the 2019 hearing officer and tribunal member update. But I know that there will be many questions and issues that appear during the course of the school year. You are welcome to call 770-601-3798 for assistance. You may also contact me at jstokes@gale.org, and I will be happy to provide consultation at no charge to you or to any other member of the school staff with regard to discipline issues. Under State Board Rule 160-4-8-.15, every administrator or person who participates in the school tribunal setting must be certified each year. You must have completed the 5-hour basic class and then complete the update each year. Once you have completed this update, please send an affidavit that you have done such to Jimmy Stokes at jstokes@gale.org. A simple email is all that's required. You will be added to the state database of hearing officers that have completed training as required by the State Board rule. You will be notified that you have completed the required training for the 2019-2020 school year. Educators that have not had the 5-hour basic training can do so through training that will be provided through the RESAs. Training will also be available at the Summer and Winter Gale Conference. Thank you very much.